Health, Education, Labor, and Pensions will please come to order. Let me say at the outset that we, I think, have some time restrictions. The 2-hour limit was not waived for the committee hearing. So at some point, I'll have to be a little bit heavier on the gavel just to make sure that we complete our work today. Americans were shocked when after the October 7th, 2023 massacre, instead of the United States uniting in solidarity to support Israel, anti-Semitism boiled out on college campuses. Students were harassed and attacked simply because they were Jewish. And Jewish families woke up every morning wondering if their child attending that university, whatever university it was safe. Today is an opportunity for the rest of the United States to show that we are with those students, to reassure parents that their children, as much as we can help make that so, will be safe from discrimination, harassment, and even potential physical abuse. We want those parents and all parents to sleep more easily. Americans send senators to Washington to deliver results, not excuses. They expect action. So let me be clear. There is no nuance in bigotry. Chasing Jewish students into a room, pounding on the door, and threatening them with violence is wrong. That is not free speech. Preventing a student from going to class, any student, because of their religion or ethnicity is wrong. That is not free speech. That is harassment and intimidation and should not be tolerated. The era of failed leadership is over. The bills we're voting on today have strong bipartisan support. Much of this work has been a decade in development, and I appreciate colleagues' commitment in getting it done. Jewish students and their families are depending upon strong leadership to protect civil rights, their civil rights. The Trump administration has made significant progress. Now is the time for Congress to do its part to ensure that all students, Jewish students as well, are safe on campus. Today's markup is doing its part, Congress doing its part. The committee is considering the Protecting Students on Campus Act, legislation I authored to ensure students know how to file civil rights complaints if they experience discrimination or harassment on their college campus. Democratic Senator John Fetterman co-leads this and has been a great partner. We're also considering the Antisemitism Awareness Act, clarifying the definition of anti-Semitism, giving the Office of Civil Rights greater tools to address discrimination against Jewish students. I appreciate Senators Tim Scott and Jackie Rosen for their leadership on this bill. I also appreciate Senator Roger Marshall for refining and strengthening the bill. So I say now to my colleagues, let's act together to move this common sense legislation forward. Jewish families, I would say all American families, are depending upon us. With that, I recognize Senator Sanders for his opening statement.
Thank you, Mr. Chairman, and let us be as clear as we can all be, and that is that hate and discrimination of any kind is beyond unacceptable and has no place in American society. In the United States of America in the year 2025, it should not be controversial to say that anti-Semitism is a horrific, vile ideology and must not be tolerated any place or any time. Let us never forget that anti-Semitism resulted in the slaughter of some 6 million Jews during the Holocaust and for thousands of years has plagued people throughout the world. Anti-Semitism must be condemned, whether it be on college campuses or any other place in our society or throughout the world. Anti-Semitism must be condemned by political leaders here in the U.S. and political leaders in other countries across the world. But today, we should also be clear that we, and I hope I speak for all of my colleagues on both sides of the aisle, condemn all forms of bigotry. Vile hatred is not something that should exist in the United States of America, whether it is anti-Semitism, racism, sexism, homophobia, xenophobia, Islamophobia, or any other forms of discrimination. And I will be offering an amendment today to make that clear. Today, while we must focus on combating anti-Semitism and all forms of bigotry, we must also make it clear that we vigorously defend the Constitution of the United States, the First Amendment of the Constitution, and the right of people in our country to peacefully protest. Let me be very clear. I worry very much that the Anti-Semitism Awareness Act that we are considering today is unconstitutional and will move us far along in the authoritarian direction that the Trump administration is taking us. Let us remember, this is an amendment that is, let us remember, this is an administration that is currently suing the media because they report stories that the president doesn't like. This is an administration that is usurping the constitutional responsibilities of Congress and shutting down agencies without congressional approval. This is an administration that responds to judicial decisions that they don't like by threatening to impeach the judges who rendered those decisions. This is an administration which seeks to punish law firms that have represented clients who took legal action against Donald Trump, his policies, or his associates. This is an administration that literally seeks to tell major universities what courses they can offer and who can teach those courses if they are to retain federal funding. This is an administration which is illegally locking up, detaining, and deporting university students and others with no warrant, with no due process, and without notifying their families. Mr. Chairman, given the reality of what is happening in America today, I think it would be very dangerous and a very bad idea to give this administration new authority to continue their unconstitutional and authoritarian ways. As you will recall, Mr. Chairman, in the recent hearing we held on this issue, we had 5 witnesses. 3 of them were invited by you. And all 5 of them made it clear, let me reiterate, all 5, including the 3 Republican witnesses, made it clear that criticizing the extremist government of Netanyahu over their policies in Gaza is not anti-Semitic. Let me repeat. One can criticize the government of Israel, government of any country on earth for their policies, and that does not make one anti-Semitic or hateful of the people in any of those countries. It goes without saying that people in the United States of America have the right to criticize any government on earth for their policies. Unfortunately and unacceptably, the Anti-Semitism Awareness Act we are considering today would label speech that criticizes the Israeli government and Netanyahu's horrific war in Gaza as anti-Semitic and a violation of civil rights laws, and that is an extremely dangerous precedent. So with that, Mr. Chairman, I should tell you we'll be offering a number of amendments that address some of these concerns that I have.
We'll now begin consideration of 2 bipartisan bills, S-558, the Anti-Semitism Awareness Act of 2025, S-163, the Protecting Students on Campus Act of 2025. For the awareness of senators and staff, we intend to vote on amendments as they are raised, but will hold the vote on final passage on both bills until the end of the session. We'll keep members and staff updated as to the timing of the vote on final passage. I'm aware that people are double and triple committed right now, and so we will give adequate time for people to return to vote for that final passage. Okay. I will ask also my colleagues to limit their remarks to 2 minutes when discussing either of the bills or offering an amendment. We have a lot of amendments to get through. And as a reminder, when discussing an amendment, please identify the amendment you're discussing by its name and by its number.
Mr. Chairman,
Senator from Kentucky.
I'd like to make a motion that those introducing their amendment be given 5 minutes. We're going to be discussing the First Amendment issues of this, and I think 2 minutes is hardly enough to scratch the surface on the First Amendment. So I would make a motion that we be allowed 5 minutes to introduce amendments and then do 2-minute follow-up questions and discussion between people. And I'd ask for a recorded vote.
Let me just comment on that. I think there's a total of 60 minutes filed. We have 2 hours to get through this. Just do the math. If we're going to pass this bill, we cannot, that is just not possible.
We could also limit the 5-minute discussion of your amendment to 1, and each person would have, 5 minutes with that particular amendment, And then we'd have no more than and I think there's also maybe on the other side, some willingness to limit and not do 60 amendments, but we want to have a fulsome discussion of this. And I mean, discussing the First Amendment ramifications of something that will alter the First Amendment and will affect every college student in America, I think is important enough to not just, I mean, we do 2 minutes. You're not even going to get started in a discussion of your amendment in 2 minutes.
Just doing the math, that would allow us to have roughly 30 amendments discussed. Right now, there's 60, and we still have to vote on final passage. Of course, I reject the premise of your argument that we're altering the First Amendment. I totally reject that. But that said, we just don't have the time.
I'd like to make the motion and have a vote on
Mr.
whether or
Chair.
not we have 5 minutes to introduce amendments.
Mr. Chair, if I could offer a friendly, perhaps we could first see how many amendments will be called up, and once we know the number that will be called up, we can look at the timing.
The part of that, Senator Kane, is that what Senator Paul's recommending is not only there be a 5-minute, but there be, as I gather, an unlimited 2-minute, 2-minute, 2-minute. This could be death of 1,000 cuts, frankly, a strategy by which to defeat the ability to consider final passage. And I say that not to suggest that Senator Paul would do that, but rather that's something that could be parlayed there.
Mr. Chairman, I am sympathetic to your need to move this bill very quickly, but these are incredibly sensitive, very complicated issues, and both you and I have been on this committee for a long time. This committee does not have a tradition of limiting debate. I think we can all try to move this as quickly as possible, but Senator Paul is right. You are not going to be able to get into the meat of these issues. You know, this is a very detailed and technical discussion about the impact of the language in the definition in one of these bills. I don't know that it serves this committee well to set a precedent in which you are going to arbitrarily limit members' ability to speak. It's not something we've traditionally done in the Health Committee.
Mr.
First,
Chairman?
that has been done in the past by my ranking member. Secondly, that I am told that there will be objections on the Senate floor to waiving the 2-hour limit to committee. Now, this could be perceived by some as a strategy by which our ability to go after hours, if you will, is not permitted. And so we're restricted by 2 hours, and then it's death by 1,000 debates of how we actually use those 2 hours. Now, let's not be disingenuous. These bills have been out here for a long time, and we've had plenty of time in the public spectrum to discuss this. We actually had a committee hearing before on discussing the anti-Semitism on college campuses, in which fulsome debate was therefore allowed time. And so, again, I'm not disparaging or implying anything about the motivations of Senator Murphy, who's got a nice-looking beard, which is a new look. But I am saying that this could be used to defeat a bill, not on the substance of the bill, but by a process. And this chairman will not allow that. Senator Scott.
Thank you, Mr. Chairman, for not allowing that, number one. Number two, since 2016, we've been discussing this bill, actually. And frankly, we've all had an opportunity to weigh in on this, and most of us have weighed in on this over the last 9 years. And frankly, both President Trump and President Biden have weighed in on this issue. Number one, President Trump making this into an executive order, and number two, President Biden keeping it as an executive order. To suggest that we haven't had an opportunity or ample time for us to have a conversation and a debate over the First Amendment ramifications is hogwash, number one. Number two, I would say that having an amendment that's reinforces the fact that this is not going to impede on our First Amendment rights is something that I believe Senator Marshall has already done. And so looking at the actual text language of this bill, this is a non-issue, not only from my perspective, but frankly from the two previous administrations.
Okay. Mr. Chairman?
Senator Sanders.
When we talk about, in my view, taking away freedom of dissent in the United States of America, that is an issue in this committee, in this bill, that should be discussed. Yeah, people may have talked about it for years. People may have talked about it off of Capitol Hill. But right now, this is the day, this is the moment in which we are discussing this bill. And I think denying senators a reasonable amount of time to express their opinion is wrong. So I support Senator Paul's effort.
Senator Paul's made a motion. We'll have a vote on it. I will point out, the more time we take this, the more heavy-handed my gavel will be in considering amendments. I will not allow this committee to be defeated on process when there's been years in order to debate the issue itself. With that, I ask the clerk to call the roll, and I shall be voting no on Senator Paul's amendment. Please call.
Senator Paul?
Yes.
Senator Collins? Senator Murkowski?
By proxy, no.
Senator Mullen?
By proxy, no.
Senator Marshall? Senator Scott? Senator Hawley?
By proxy, no.
Senator Tuberville? Senator Banks? Senator Houston? Senator Moody?
By proxy, no.
Senator Sanders?
Yes.
Senator Murray?
Yes, by proxy.
Senator Baldwin? Senator Murphy? Senator Kane? Senator Hassan? Senator Hickenlooper? Senator Markey?
Yes, by proxy.
Senator Kim? Senator Blunt Rochester? Senator Alsobrooks?
Yes, by proxy.
Chairman Cassidy?
No.
I have 11 ayes, 12 nays.
Okay. Let's begin with consideration of S558, the Antisemitism Awareness Act of 2025. Before I introduce the manager's amendment, I recognize Senator Tim Scott, the bill sponsor, to introduce the bill. He is recognized for 2 minutes.
Thank you, Mr. Chairman, and thank you to the committee for considering this important legislation. Once again, since 2016, I've been fighting for this cause. Both President Trump and President Biden. President Trump making it into an executive order, President Biden preserving it as an executive order. This bill does not provide any additional authorities to the President of the United States. So thank you for listening. There can be no equivocating when it comes to anti-Jewish violence and harassment. It's critical that the Department of Education has the tools to investigate anti-Semitism and root out the vile hatred wherever it rears its ugly head. The Antisemitism Awareness Act does just that. It provides a tool to help the department and universities identify and address anti-Semitism. That tool is the IRA definition and its contemporary examples. This is why I have championed the legislation since 2016 and will continue to do so until it is signed into law. I look forward to passing this bill out of committee today, and I urge all my colleagues to join me in supporting it. Thank you, Mr. Chairman.
Mr. Chairman.
Senator Paul.
The manager's amendment adds a all-inclusive, but we'll always obey the First Amendment, we'll never do anything to protected speech. The problem is if you look at the IHRA examples of speech they're going to be limiting on college campuses, everything on that list is politically protected by the First Amendment. In fact, if you look at Brandenburg versus Ohio, the operative case on First Amendment, every one of these things. The First Amendment isn't about protecting good speech. It protects even the most despicable and vile speech. Brandenburg was a Nazi and an anti-Semite, and he said horrible things. And the First Amendment, the Constitution, the Supreme Court ruled that you can say terrible things. That's unique about our country. In Europe, you can't say anything. In Europe, you can, if you call a boy that thinks he's a girl a boy, you can go to jail for that. If you say something about the Holocaust in Europe, you can go to jail. This is what we're doing. We're codifying what Europe did to speech. It's a terrible idea. But everything in the 11 examples is protected by Brandenburg, without question. And so when you say, oh yeah, we're gonna do all these and we're still gonna have all these examples of things you can't do, like stereotypical allegations. Have you guys ever listened to comedy? Do you know why Jerry Seinfeld won't go to colleges? Because he can't make any Jew jokes anymore. You know, the thing is, or Indian jokes, or whatever jokes. Jokes are about silly categorizations of people, you know, of saying all people do things. One of my favorites I just saw this morning was from Jon Stewart. If the Jews control the media, why don't we give ourselves better press? Is that going to be controlled? Yeah, and I'm not that funny. I just stole that from Jon Stewart. But the thing is that going to be controlled? Will Jon Stewart be allowed to say that on a college campus? Are we going to send the Title VI police after him? I mean, this is just ridiculous and terrible. We all condemn anti-Semitism. We all just, are against bigotry. And yet, this is a step backwards.
For next one. That's what we'll do.
I will point out that this bill simply clarifies the definition of anti-Semitism for the OCR complaint process. Students still have the right to express an opinion, but not the right to harass others. We have a manager's amendment to S558. I move to adopt the manager's amendment in the nature of a substitute and to have it considered original text for the purpose of further amendments. All those in favor, please say aye. Aye. All opposed, say nay. Nay. The ayes have it, and the motion is agreed to. Are there any members who wish to speak on or offer an amendment to S558? Senator Paul.
This is Paul Amendment 1. It is repugnant to support the atrocities of October 7th. It is equally inappropriate for the Senate to impose new speech limits. My substitute amendment would simply identify Israel as the victim of October 7th and condemn Hamas for its brutality. This bill would subject to punishment speech claiming that Jews killed Jesus, an absurd and insulting insinuation if the argument is that all Jews are responsible for killing Jesus. And yet, the Gospel of John describes the trial and crucifixion of Jesus. It reports Jews present at the trial, including the high priest and crowd, called for his crucifixion. Nobody thinks that's all Jews, but you're no longer allowed to read John 18 and 19. This is sort of insane. It sort of begs the belief that nobody even understands that in first century there were Jews that collaborated with the Romans. They were despised by the other Jews. It was a sectarian conflict that went on. But if you're not even willing to acknowledge that, we just can't say this. I mean, this is crazy. Albert Mohler, the president of the Southern Baptist Theological Seminary and Boyce College, criticized this legislation by saying that the simple preaching of the gospel could be targeted by the bill, and by the loose logic of the entire New Testament can be targeted as hate speech. James Carroll's book, Constantine's Sword, repudiates the ancient charge that the Jews are guilty of the violent murder of God and shows that the epithet that the Jews killed Jesus is an anti-Semitic trope. But banning speech allows the trope to fester. Even Kenneth Stern, who drafted the bill's definition, opposes codifying the definition of anti-Semitism into law. Appearing before the Judiciary Committee, Stern, who wrote this definition, said principles about speech have to apply to speech one doesn't like too. That doesn't mean ignore the speech. It means not to use laws to chill or stop it. Sadly, the definition has been used for precisely this anti-speech purpose in Title VI. Let us heed his advice. A free society is strong enough to confidently and persuasively ignore arguments, not silence them.
As stated earlier, we will vote on this. This amendment would kill the underlying bill. Every senator on this committee has condemned Hamas and anti-Semitism. This is an unnecessary resolution that would kill the substantive legislation. I'd ask the clerk, Senator Sanders.
I thank Senator Paul for offering this amendment. I would have worded it differently, but I think the essence of what he's trying to do is correct, and I encourage my colleagues to support it.
Okay. The clerk should call the roll.
Senator Paul?
Aye.
Senator Collins?
No by proxy.
Senator Murkowski?
No by proxy.
Senator Mullen?
No by proxy.
Senator Marshall? No. Senator Scott? No. Senator Hawley?
No by proxy.
Senator Tuberville? Senator Banks? Senator Husted? No. Senator Moody?
No by proxy.
Senator Sanders?
Yes.
Senator Murray?
Yes, by proxy.
Senator Baldwin? Senator Murphy? Senator Kane? Senator Hassan? Senator Hickenlooper? Senator Markey?
Yes, by proxy.
Senator Kim? Senator Blunt Rochester? Senator Alsobrooks?
Yes, by proxy.
Chairman Cassidy?
No.
I have 11 ayes, 12 nays.
Who else has an amendment which I'd like to bring up? Senator
I've got
Kane.
an amendment.
Kane, you want to go Sanders first?
Yeah. I call it Sanders Amendment Number 2. Mr. Chairman, as you will recall, in the recent hearing we held on this issue, all 5 witnesses, including 3 Republican witnesses, made it clear that criticizing the extremist government of Netanyahu over their policies in Gaza is not anti-Semitic. One can criticize the government of Israel for their policies without being anti-Semitic. This amendment makes it clear that it is not anti-Semitic to oppose the Netanyahu-led war effort that has killed more than 50,000 people and wounded over 116,000, 60% of whom are women, children, and the elderly. Making that point is not anti-Semitic. It is not anti-Semitic to criticize Netanyahu's war machine that has damaged or destroyed 2/3 of all structures in Gaza, including 92% of the housing units. It is not anti-Semitic to speak out against the extremist Israeli government for not allowing a single shipment of aid into Gaza in over 2 months, 62 days and counting. To point this out is not anti-Semitic, it is the truth. I urge my colleagues to vote yes on this amendment.
Senator Hassan.
Thank you. Just briefly, Mr. Chair, on Sanders Amendment 2, I will say that this amendment doesn't necessarily reflect the words that I would use in describing the full picture in Gaza. But just saying these words doesn't make you an anti-Semite. And so while I continue to remind people that this war would end if Hamas would put down its arms, we do have a First Amendment in this country that protects the freedom of speech. Thank you.
So, Senator Murphy.
Thank you very much, Mr. Chairman. I'm going to support the senator's amendment, and it speaks to, I think, a really important issue in the underlying bill. The author of this definition has testified publicly that he never intended for the definition that ended up in statute to include the litany of examples that are offered as part of the guidance on how to implement this definition. This is really important because if you read these examples, which are going to be incorporated by law into this new definition, it absolutely opens up the possibility that criticism of Israel, for instance, suggesting that there is discrimination or bias against Palestinians connected to decisions that the government is making as actions or speech that could ultimately cause your federal funding to be in jeopardy. If you argued that there was bias or discrimination inherent in an exercise of the U.S. government, you would not be held liable, you would not be at risk of losing your federal funding. But under this definition, which includes the examples, there is a real potential that First Amendment protected speech, criticism of Israel, the policies of Israel, will end up getting you in trouble and putting your federal funding at risk. So I wish we had listened to the author of the definition. The author of the definition would support the definition itself as being complete and total enough in order to protect against anti-Semitism on campus. The reason that many of us are having trouble with this bill is because of the incorporation of the examples that were never, ever intended to become law and will just make this definition very confusing for an administration or courts to ultimately interpret and administer.
So, Senator, I'm about to recognize Senator Paul. I'm just going to tell folks this is actually not our jurisdiction. As this amendment is phrased, this is Senate Foreign Relations. And so I'm just telling you that. We're going to have a lot of discussion, and I'm going to have a gavel. I've asked my staff, we're going to get through this bill.
Or you can have a gavel, but this is an issue that is relevant to this committee. This is the heart of what we're debating today.
This is a Senate Finance, this is a Senate Foreign Relations Committee, Senator Sanders.
No, we're not debating the war in Gaza. We're debating this
Amendment is there. So, Senator Paul.
Senators, what is the rule? Is the rule that we each get 2 minutes on each amendment? Okay, so you're not going to gavel down individuals who are speaking.
We are going to finish by noon because our time here is restricted. And I'm not going to allow process to kill our final passage by a death of 1,000 conversations.
Well, you set a very restrictive debate rule, and I just want to make sure you're holding to that. We all get the ability to speak
And it may
for
get
2 minutes
ratcheted
on
even
each
further
amendment. Is
down.
that correct?
Because let's not be naive. This is a strategy to defeat final passage on something which has been out there for 6
Chairman,
years.
this is
So
a very
Senator Paul,
important issue, Mr.
Senator
Chairman.
Paul.
You know, I think imputing what the goals are of each of us in discussing this, my goal is to further the debate and have a very intellectual and informed debate over this. So there are 11 examples that are listed that could be anti-Semitism. One of them says that claiming the existence of the state of Israel is a racist endeavor. Well, what if I repeat that Netanyahu says that Israel is a Jewish state? Well, Jewish is a race, and if he says it's a Jewish state, just by repeating Netanyahu, could I be guilty of anti-Semitism? So, you know, the thing is there are questions, there are valid questions that people ask. So if you're a settler on the West Bank and you're Jewish, you get to vote in the Israeli elections. If you're Arab and you live on the West Bank, you don't. So is that fair, or is that me condemning, the citizenship or making allegations that are going to be, limited by this bill? So these are really important, and this is really the main objections that have come to this. If we did a standard sort of, we condemn anti-Semitism, it'd probably be passed with everybody voting for it. But instead, we are listing all these things that open Pandora's box, and realize that the police are behind this. The Department of Education has police. You may not know this, but the Department of Education actually has armed police. So they can send people to the campus to police this type of speech. And, seriously, it is actually advocated by the current government of Israel that it be a Jewish state and always remain a Jewish state. That is a racial statement. That's not my statement, that's their statement. So is it going to be disallowed by this bill for a student to say that on campus?
So
Chairman, I would call the question.
there is a motion. I'm going to make a motion to table this amendment. Is there a second?
Well, I made a motion to call the question. Mr. Chairman, I would like a vote on my amendment.
Motion to table because of absence of jurisdiction. Is there a second?
Second.
There's a second. It's non-debatable. Clerk shall call a roll.
Senator Paul?
No.
Senator Collins?
No by proxy?
Senator Murkowski?
I mean, yeah, I'm sorry, yes by proxy?
Yes, by proxy. Okay. All right. Senator Murkowski? Senator,
Yes by proxy?
Senator Mullen?
Yes by proxy?
Senator Marshall? Senator Scott? Senator Hawley?
Yes by proxy?
Senator Tupperville? Senator Banks? Senator Husted? Senator Moody?
Yes by proxy?
Senator Sanders?
No.
Senator Murray?
No by proxy.
Senator Baldwin?
No by proxy.
Senator Murphy? Senator Kane? Senator Hassan? Senator Hickenlooper? Senator Markey? Senator Kim? Senator Blunt Rochester? Senator Alsobrooks?
No by proxy.
Chairman Cassidy?
Senator Cassidy is a yes, and I'll also point out that we would not have the restrictions on debate had minority agreed to go beyond 2 hours. Now, the idea that somehow we're doing restrictions because of something that is heavy-handed on my part when we've not had an agreement to go beyond 2 hours is deceitful to the American people. Deceitful. So, with that said, staff?
I have 11 ayes, 12 nays.
Okay. So do we now have a?
What? Hold it.
So motion table was not agreed to yet.
So,
Oh, okay. Right. Right.
now we'll have a vote on the amendment.
Correct.
The chairman will call the roll.
Call roll. Okay.
And these, I shall be voting no.
Senator Paul?
Aye.
Senator Collins?
No by proxy.
Senator Murkowski?
No by proxy.
Senator Mullen?
No by proxy.
Senator Marshall? Senator Scott? Senator Hawley?
No by proxy?
Senator Tupperville?
No by proxy.
Senator Banks? No. Senator Houston? No. Senator Moody?
No by proxy.
Senator Sanders?
Aye.
Senator Murray?
Aye by proxy.
Senator Baldwin?
Aye by proxy.
Senator Murphy? Senator Kane? Senator Hassan? Senator Hickenlooper? Senator Markey? Senator Kim? Senator Blunt Rochester? Senator Alsobrooks?
Aye by proxy.
Chairman Cassidy?
Senator Cassidy is a no.
I have 12 ayes, 11 nays.
Okay. The amendment fails. Amendment is agreed to.
Amendments agreed to, yes.
Agreed to. Yeah. Okay. Okay. Senator Kane.
Kane won, but you don't need to distribute it because I'm not going to offer it for a vote. I'm going to take my 2 minutes to explain the amendment and also use the 2 minutes to explain my opposition to the bill. What Kane 1 would have done is very simple. In the definitional section, it just would have dropped the contemporary examples of anti-Semitism adopted in the IRHA definition. Maintained the definition, but dropped the examples. The reason I wanted to do that, but I've nose counted and I'm going to lose, so I'm not even going to call it for a vote. The reason is this is an important civil rights statute. Like other statutes, EEOC, 42 U.S.C. 1982, the examples are all in the may. I'm going to read from the IRHA definition. To guide IRHA in its work, the following examples may serve as illustrations, which means may or may not serve as illustrations. I am not aware of a single other civil rights bill where we are condemning behavior, but in the statute saying this may or may not be an example of the bad behavior. We don't do this in civil rights statutes. And so from the beginning, from a draftsmanship standpoint, anti-Semitism is very serious. Calling someone an anti-Semite is very serious. And I don't think we should put into the statutory definition a set of examples that are, well, maybe it is, maybe it isn't. We would be setting a very bad draftsmanship precedent, number one. Number two, the examples of the 11 examples, 7 are really about Israel. 4 are about anti-Semitism, about Jews. 7 are really about Israel. And for the reasons mentioned earlier, yesterday the head of the Shin Bet resigned in Israel and leveled a very tough set of charges against the prime minister and the Israeli government. I think much of what he said in that would violate this definition. We should allow people to state tough points of view, even if we don't agree with them. So I am going to, recognizing that I'm not going to succeed in convincing my colleagues to remove the examples, I'm going to oppose the bill. If we could have had the votes to remove the examples, I would have supported it, but I'm going to oppose the bill. And with that, I yield back. I will not call up Kane 1 for a vote.
Mr. Chairman.
Senator Paul.
So we're talking about these 11 additional things that go with the definitions. One of them is the bill would punish speech that draws comparison of Israeli policy to that of the Nazis. Boy, I wonder if we'll next apply this to Donald Trump, because most of the Democrats in the country think Donald Trump's a Nazi, you know? The thing is, I think it's a terrible sort of comparison because it demeans what happened during the Holocaust to call anybody Nazis or Hitler or whatever you want to do. So it's not very effective and often backfires when people do it, but I wouldn't make it illegal. I mean, for goodness sakes, that's just ridiculous. We're going to make it illegal to compare somebody to historical figures that people don't like. I mean, really, what kind of, has anybody thought through the idea of passing a law that you can send the Department of Education police to a campus because some kid said that the Israeli government are acting like Nazis?
Are you commenting on Senator Kane's
amendment? Yeah, because his amendment
Well, he withdrew the amendment.
His amendment was to remove the 11 contemporary examples. I mean, I kind of wish we'd still vote on it because people ought to be on record as having supported specifically things that condemn a comparison to Nazis, because both parties do it. When we really hate somebody, who do you compare them to? The worst person in history, Hitler or the Nazis? And like I say, it's not a great argument, but to live in a society where it's illegal to compare someone to Nazis, I think is a huge mistake. and an abbreviation of the First Amendment, not correct under Brandenburg, not correct under the Supreme Court, and would go a long way towards striking this down as unconstitutional.
The bill contains protections for free speech. I recognize Senator Scott.
Yeah, thank you, Mr. Chairman. Just say it one more time, probably not just one more time, but what the bill clearly says is that the speech itself is constitutionally protected. It's the conduct that follows the speech that creates the harassment, not the speech itself. So every example we've used so far, the speech itself is protected. You can say it. It's if you do something that is a conduct that follows that speech, it gives you the link back to whether or not it's anti-Semitic or not, as examples.
Does someone else have an amendment? Senator Markey, you're. Senator Markey.
Mr. Chairman, this is Markey number one. For the past 100 days, the Trump administration has time and again demonstrated a callous disregard for the rule of law. In March, under the guise of anti-Semitism investigation, the Trump administration canceled $400 million in funding for Columbia University. There had been no due process, no findings of fault. Instead, the administration sent a list of demands dictating faculty hiring decisions and security and public health measures. 1 month later, this administration did it again and terminated a reported $2.2 billion in funding to Harvard with no investigation, no due process, no findings of fault. The administration has also threatened to cut another $1 billion in federal research funding for Harvard and sent a list of demands that would interfere with academic freedom and allow the administration to force the university to comply with its ideology. Harvard responded forcefully and, as its president, Alan Garber, stated, refused to surrender their independence and relinquish their constitutional rights. Title IV of the Civil Rights Act clearly allows universities the opportunity for a fair investigation, a hearing, a chance to redress any wrongs. But Trump has decided yet again that his administration is above the law, that they can treat congressionally authorized funding like a piggy bank and congressionally enacted legislation like a suggestion. His disregard for the rule of law is dangerous, and I urge my colleagues to vote to ensure that due process is protected and that Trump's lawless funding cuts may be reversed.
The Antisemitism Act is focused on standardizing the definition of antisemitism for the enforcement of federal anti-discrimination laws. This legislation is not the place to consider procedural changes to the processes through which the federal government terminates grants due to non-compliance with anti-discrimination laws. I recognize this is an important issue to members of the committee. It is not within the scope of the legislation we are considering, so I move to table Markey 1. Is there a sufficient second? There's a sufficient second. The clerk shall call the roll.
If I may, may I comment on your?
It's not debatable. For clarification, a yes vote means the amendment will be placed on the table and no longer considered for passage. I shall be voting yes. The clerk shall call the roll.
Senator Paul?
Yes.
Senator Collins?
Aye by proxy.
Senator Murkowski?
Aye by proxy.
Senator Mullen?
Aye by proxy.
Senator Marshall?
I don't have to table.
Senator Scott?
Table me, I think.
Senator Hawley?
Aye by proxy.
Senator Tuberville?
Aye by proxy.
Senator Banks? Senator Houston? Senator Moody?
Aye by proxy.
Senator Sanders?
No.
Senator Murray?
No by proxy.
Senator Baldwin?
No by proxy.
Senator Murphy? Senator Kane? No? No. Senator Hassan?
No.
Senator Hickenlooper? No. Senator Markey?
No?
Senator Kim? No. Senator Blunt Rochester? Senator Alsobrooks?
No by proxy.
Chairman Cassidy?
This Senator Cassidy is voting yes to table.
I have 12 ayes, 11 nays.
For my colleagues, recall that this markup will not be the last time available to debate this bill. There will be additional time on the floor, knowing that there might be other issues that the time limit placed upon us will not allow full consideration. Does anyone else have an amendment? Senator Markey.
Yeah, Markey number 3. The Trump administration has cut billions of dollars in federal research funding to colleges and universities under the guise of civil rights investigations. When this administration cuts this funding, here's who was impacted. Researchers studying Alzheimer's, stroke, heart disease, and HIV at Harvard, who now can't do their work. Funding for diabetes research has been cut. Essential work into how to improve treatments, cure disease, build a better world stops. And the families waiting for a breakthrough cancer treatment or a cure for Alzheimer's are forced to wait longer. The administration is making profound decisions that could determine whether workers keep their jobs, if students, faculty, and staff can truly have the freedom of expression required under the First Amendment, and whether research that may determine life and death for many Americans can continue. Yet this far, Congress has no role and no insight into their decisions. This amendment merely requires notice to Congress before the administration decides to cut research grant funding from the Departments of Education, Labor, or Health and Human Services to the schools that they are right now punishing. This will give Congress the information needed for essential and appropriate oversight. What the Trump administration is to universities isn't effective civil rights enforcement. It isn't a way to solve anti-Semitism. It is blackmail. It is the use of force to restrict freedom, and people are getting hurt, especially those who will not have the cure for cancer or Alzheimer's that otherwise might have been available. Congress deserves to know what's going on and have the opportunity to intervene where appropriate. I hope my colleagues will join me in voting yes on this amendment.
This amendment is unrelated to anti-Semitism or anti-discrimination more broadly. It's also a duplicate of Markey S558 Amendment Number 2, except that Number 3 lists an additional committee among those at which have to be notified. I recognize this is important to Senator Markey. It's not within the scope of the legislation that we are considering, so I shall move to table Amendment S558 Amendment Number 3. Is there a sufficient second? There is a sufficient second. For clarification, a yes vote means the amendment will be placed on the table and no longer considered for passage. I shall be voting yes. The clerk shall call the roll.
Senator Paul? Aye. Senator Collins?
Aye. By proxy.
Senator Murkowski?
Aye by proxy.
Senator Mullen?
Aye by proxy.
Senator Marshall? Aye. Senator Scott? Aye. Senator Hawley?
Aye by proxy.
Senator Tupperville?
Aye by proxy.
Senator Banks?
Aye by proxy.
Senator Husted? Senator Moody?
Aye by proxy.
Senator Sanders?
No.
Senator Murray?
No by proxy.
Senator Baldwin?
No by proxy.
Senator Murphy? No. Senator Kane? No. Senator Hassan? No. Senator Hickenlooper? No. Senator Markey?
Nope.
Senator Kim? No. Senator Blunt Rochester? Senator Alsobrooks?
No, I'm sorry, no by proxy.
Chairman Cassidy?
Cassidy is voting yes to table.
I have 12 ayes, 11 nays to table.
Mr. Chairman, could I ask for the parliamentarian of this committee to rule on the germaneness of my amendment?
It's not about germaneness. The motion to table. It's non-debatable.
You're making the motion to table based upon its germaneness to this committee's ability to raise issues related to anti-Semitism and cuts to research for...
The justification of the amendment does not matter. It is a motion to table. It's non-debatable. We've got about 10 more minutes to do this amendment, to do this bill, and then we're moving on. Again, we were placed in a time restriction by the minority, and there will be additional time to debate when we get to the floor. Is there someone with another amendment?
Well, I have another amendment, but Senator Markey asked a simple question. He wanted to hear from the parliamentarian the justification of your
The
decision.
motion to table is not debatable. Senator Sanders, what did you...
I have a motion, and I would also point out, there is another day to continue discussion. As Senator Paul mentioned earlier, we are dealing with an enormously inconsequential issue having to do with the First Amendment. And to rush this thing through and not allow full debate on these amendments is absolutely inappropriate, not in the spirit of this committee.
Disingenuous, the minority should have allowed us more than 2 hours.
This is nothing new.
So
This
that's
is
said.
what has gone on for
Sanders
years.
Amendment.
Mr. Chairman.
Call up.
Mr. Chairman. Mr. Chairman.
This is not debatable. We are moving on. If you wish to bring up another amendment, if not, I shall move on to the next bill. Does anyone have another amendment they wish to
Yeah,
bring
I
up?
got 5 amendments.
Then please bring it
All
up.
right. I call up Sanders Amendment number 11. Mr. Chairman, a few weeks ago, the Trump administration arbitrarily fired every federal worker who administers the bipartisan low-income home energy assistance program. That's LIHEAP. Now, in cold weather states like Vermont, LIHEAP is life and death for many people, especially senior citizens who need help keeping their homes warm in the wintertime. In hot weather states, it is equally important when August comes and people need help maintaining air conditioning. What this amendment would do is immediately reinstate all of the LIHEAP staff that were terminated, reopen the Division of Energy Assistance that administers this program, and disperse all of the LIHEAP funds that Congress has appropriated. Being able to heat your home in the freezing cold and keep the air conditioner on in the extreme heat is not a luxury. It's a matter of life and death. I urge my colleagues to vote for this amendment.
This is a partisan amendment. The Antisemitism Awareness Act is focused on standardizing the definition of antisemitism for the enforcement of federal anti-discrimination laws. The legislation is not the place to consider potential funding, staffing, or organizational changes to HHS. With that, while I recognize this is important to Senator Sanders, it's not within the scope. I move to table S558 Amendment Sanders number 11. Is there a sufficient second? There is. For clarification, a yes vote means the amendment will be placed on the table and no longer considered for passage. I shall be voting yes. The clerk shall call the roll.
Senator Paul? Aye. Senator Collins?
Aye.
Senator Murkowski?
Aye.
Senator Mullen?
Aye.
Senator
By
Marshall?
by proxy, I'm sorry.
Sorry. Senator Marshall? Yes. Senator Scott? Yes. Senator Hawley?
Aye by proxy.
Senator Hawley?
Aye by proxy.
Oh, sorry. Senator Tuberville?
Aye by proxy.
Senator Banks?
Aye by proxy.
Senator Houston? Yes. Senator Moody?
Aye by proxy.
Senator Sanders?
No.
Senator Murray?
No by proxy.
Senator Baldwin?
No by proxy.
Senator Murphy? Senator Kane? Senator Hassan? Senator Hickenlooper? Senator Markey?
Nope.
Senator Kim? Senator Blunt Rochester? Senator Alsobrooks?
No by proxy.
Does
Chairman Cassidy?
Cassidy votes yes to table?
I have 12 ayes, 11 nays.
Okay. Does anyone else have an amendment?
Yep. All right, do you want to go?
Senator Markey.
Thank you, Mr. Chairman. This is marquee number 4. Over the last few weeks, the Trump administration has abducted international students and faculty off of the streets of the United States of America and quickly moved them out of their states to bypass judicial oversight, shipped them off to detention facilities far from their communities in Louisiana. In short, people are being detained for nothing more than engaging in the freedom of expression that is explicitly protected under the First Amendment of the United States Constitution. Last week, I went down to Louisiana to meet some of those students, including Ramesa Ozturk, a graduate student at Tufts University. What I saw should bring chills down the spines of anyone who cares about the First Amendment. The Trump administration is detaining students for nothing more than engaging in the freedom of expression that is explicitly protected under the First Amendment of the Constitution. The students which I met with have not been charged with a single crime, and they're still behind bars. They haven't been charged with a crime. There's no evidence. Whether you agree with what these students have written or said, when a government imprisons writers for their words, when it abandons legal norms, including due process for political convenience, when it cloaks oppression in the language of national security, then we must call this out as a violation of the First Amendment. Without a robust right to speak freely, without a fear of retaliation or reprisal, our most basic freedoms are jeopardized. And I urge my colleagues to acknowledge as much in this committee today, because this just goes to the heart of it. There are young people right now behind bars not charged with anything. Marco Rubio just can't say someone is a national security threat, and they're whisked off the streets by 6 masked law enforcement officials, not given access to a lawyer, not told what they're charged with, never charged with a crime. We're better than that. That's not what our Constitution stands for. So I urge and I vote.
It's my determination that this amendment, obviously immigration, lies outside this committee's jurisdiction. It violates Rule 15 of the standing rules of the Senate. Accordingly, I rule it out of order. Next amendment.
This is not out of order. This is the point of this hearing. It is to protect people.
This is the Senate Judiciary Committee. Next amendment.
Oh, yeah, I ask for a vote on Senator Markey's amendment.
It's out of order.
I ask for a ruling on the part of the parliamentarian, or can you just do anything you want?
This is at the discretion of the chair.
I ask for a motion to overturn.
Senator Sanders.
I ask for a motion to overturn. What Markey is
Sanders
talking
is-
about is enormously
Senator
important.
Sanders has called for an appeal for the ruling of the chair. For clarity, a no vote upholds the ruling of the chair that the amendment is out of order. It is an important amendment, but it's Senate Judiciary. I shall be voting no. The clerk shall call the roll.
Senator Paul,
Explain the vote again.
If you vote no, you,
This is to overturn the chair. I'll vote yes.
you're voting yes to overturn the chair on this being a germane.
Yeah, I'm for the amendment. It has to do with the First Amendment. I mean, I think it's pertinent.
Okay, that's interesting. Okay.
Senator Collins,
No by proxy.
Senator Murkowski,
No by proxy.
Senator Mullen,
No by proxy.
Senator Marshall, Senator Scott, Senator Hawley,
No by proxy.
Senator Tuberville,
No by proxy.
Senator Banks,
No by proxy.
Senator Houston, Senator Moody,
No by proxy.
Senator Sanders,
Yes.
Senator Murray,
Yes, by proxy.
Senator Baldwin,
Yes, by proxy.
Senator Murphy, Senator Kane, Senator Hassan, Senator Hickenlooper, Senator Markey,
Yes.
Senator Kim, Senator Blunt Rochester,
Yes, by proxy.
Senator Alsobrooks,
Yes, by proxy.
Chairman Cassidy.
No.
I have 12 ayes, 11 nays.
Okay.
The ruling's been overturned.
Okay. Now we proceed to the Markey amendment.
Call for a vote on the Markey Amendment. The chair shall be voting no. The clerk should call the roll.
Senator Paul,
Aye.
Senator Collins,
No by proxy.
Senator Murkowski,
No by proxy.
Senator Mullen,
No by proxy.
Senator Marshall, Senator Scott, Senator Hawley,
No by proxy.
Senator Tuberville,
No by proxy.
Senator Banks,
No by proxy.
Senator Houston, Senator Moody,
No by proxy.
Senator Sanders,
Yes.
Senator Murray,
Aye by proxy.
Senator Baldwin,
Aye by proxy.
Senator Murphy, Senator Kane, Senator Hassan, Senator Hickenlooper, Senator Markey,
Aye.
Senator Kim, Senator Blunt Rochester,
Aye by proxy. Oops, she's here. Okay.
Senator Alsobrooks,
Aye by proxy.
Chairman Cassidy.
Senator Cassidy votes no.
I have 12 ayes, 11 nays.
Mr. Chairman?
Amendment's agreed to.
Let me just make a quick comment. So that it's clear for the people who are watching, however they might be watching, supporting these amendments is an effort to kill this bill, which protects Jewish students from anti-Semitic acts. It is also, just to say once more, the bill includes protections for free speech. So let's not be naive as to what's taking place here. Senator Sanders.
Let's not be naive. Supporting this bill, among other things, reestablishes due process in the United States and says that federal agents cannot pick people up off of the comment responding to your statement, throw them into cars and put them in detention centers without making any charges against them at all. a clear violation of the Constitution. Mr.
like to-
Chairman, I have an amendment.
Mr. Chairman?
No, Senator Sanders, we got to get out of here. Senator Sanders, your amendment.
Mr. Chairman, you were commenting upon my amendment just then.
Senator Sanders' amendment.
I would yield to Senator
Mr. Chairman,
Markey.
Okay, just start the clock.
Mr. Chairman, just anti-Semitism is wrong. Authoritarianism is not the answer. That's what we're debating right now. We're debating what the rights are of all Americans to participate in the debate.
got about a minute
When a
40
young
to talk
person
about your
writes an op-ed in a student newspaper and gets whisked off the streets
All right, I have
of
an
Tufts
amendment.
University
I've got an
to a
amendment.
prison in Louisiana with no charges,
Okay.
that is what we
I call
are
up-
debating today.
I call up Sanders' Amendment number 6. This amendment makes it clear that the federal government shall protect the First Amendment rights of college students and that the federal government shall not compel a school, college, or university to violate the First Amendment rights of a student or professor. We have already seen attack after attack on freedom of speech and right to dissent. This amendment defends the Constitution of the United States and our First Amendment.
I'd like to speak in favor.
Senator Paul.
The Supreme Court made it clear in Brandenburg versus Ohio that speech can be suppressed only if the speech is intended and likely to produce imminent lawless action. They've added an amendment to this bill saying, well, the First Amendment is going to protect your speech and this bill will do nothing to your speech. But then they list 11 things in defining what they're going to have to that say, include things like accusing and saying. They're all speech that's being regulated. Do you have a contradiction? They said they're going to obey the First Amendment, then they say, well, these 11 things are going to be adhered to, which all are in contradiction to the Supreme Court and the First Amendment. In the Brandenburg case, the speech in question was made by a hood-wearing leader of the Ku Klux Klan named Clarence Brandenburg. Despite the horrid nature of the speech in question, America's commitment to free expression is best exemplified by the people who defended Brandenburg. 2 lawyers for the ACLU, Melvin Wolfe, a Jewish man, and Eleanor Norms Houghton, a young black woman who's still in Congress. Norton later explained that she decided to defend Brandenburg's First Amendment right because free speech is worth defending even when you don't like what is being said. To me, that's been the greatness of the Brandenburg decision, is that it was by people who despised, a black woman who despised the language he was using and the racism, and a Jewish lawyer who also despised the anti-Semitism. That is what's so great about our country, is that we allow people to say things that we completely object to, and we counter bad things and bad statements, we counter bad information, bad speech with more speech. The First Amendment controls would be worthwhile in this bill only if you eliminated the 11 definitions that are all speech violations that go against the First Amendment. I'll support the bill if we get rid of the 11 definitions. I would propose that we should actually vote on Senator Kane's resolution.
The federal government cannot compel anyone to do something that is unconstitutional. This is unnecessary. For timing purposes, we're going to proceed to the vote. I shall be voting no. The clerk shall call the roll.
Senator Paul?
Aye.
Senator Collins?
No by proxy.
Senator Murkowski?
No by proxy.
Senator Mullen?
No by proxy.
Senator Marshall? No. Senator Scott?
No.
Senator Hawley?
I'm sorry. I'm sorry, Collins is an aye by proxy.
Collins is an aye by proxy. Okay.
And so who was the last one?
Senator Tuberville?
He's a no by proxy.
1, 2, 3, 4. Oh, sorry. Senator Hawley?
No by proxy.
Hawley. 1, 2, 3, 4, 5. Senator Tuberville?
No by proxy.
Senator Banks?
No by proxy.
Senator Houston?
No by proxy.
Senator Moody?
No by proxy.
Senator Sanders?
Aye.
Senator Murray?
Aye by proxy.
Senator Baldwin?
Aye by proxy.
Senator Murphy? Senator Kane? Senator Hassan? Senator Hickenlooper? Senator Markey? Senator Kim? Senator Blunt Rochester?
Aye by proxy.
Senator Alsterbrooks? Chairman Cassidy?
Senator Cassidy is a no.
I have 13 ayes, 10 nays.
For the purposes of timing, we have a time for 2 more amendments.
Whoa.
And we should, after these next 2 amendments, we'll have to move on to the next bill.
What precedent is there to tell people that they cannot offer an amendment and an enormously important markup. You cannot, what? We don't have any precedent for doing that. You can't just simply say you can't offer an amendment, sorry.
This is because of the constraints placed upon us by the minority. In terms of time, I was willing to stay here all afternoon. There are restraints complained on, that's part of a strategy, frankly, to defeat this bill. So it's unfortunate, but that's the constraints. It is the discretion of the chair. And like I said, this bill should not be defeated by death by 1,000 by process. Again, the minority had the option to give us time to fully debate, and the minority chose not to. We have time for 2 more amendments.
Hold it. As the chairman knows, what's happening here has gone on for years. There's nothing new, no great conspiracy to stop this committee. This is an important issue. People are prepared to come back on another day to continue this debate.
Will you waive the 2-hour rule?
Well, I don't have the authority to waive the rule. Call up your leader, Mr. Thune.
Well, it was Senator Schumer who refused.
Call up Mr. Schumer. But this is nothing new. This has gone on for years.
We have time for 2 more amendments.
Well, we certainly want to get a vote on, where are we now? On my amendment, yeah.
Why can't we just come back to, why can't we, listen, you are hearing not illegitimate concern and grievance from members of this committee.
Senator Sanders, are you ready with your amendment?
Why can't we just come back tomorrow to continue the market? This is an incredibly serious issue.
Then the minority should have allowed us longer than 2 hours. Senator Sanders, do you have an amendment?
Come back tomorrow and continue the market. What's the reason we can't do that?
Because then you would give us another 2-hour limit, and then it wouldn't happen.
In other words, there would be freedom of debate.
So
I think.
Senator Sanders, do you have an amendment?
You have an amendment?
Thank you.
Mr. Chair, I have an amendment at the desk. I call up my amendment, also Brooks number 1, to S558 and ask for the yeas and nays. I want to begin by underscoring that anti-Semitism is a very real and rising threat in our country. Any act of hate or form of discrimination is unacceptable and must be condemned. We need our federal government to have the tools and resources to combat hate in all forms, whether that be hate directed toward the Jewish community or whether that hate be directed toward the Black, LGBTQ students, or individuals with disabilities. Unfortunately, this administration is actively undermining our civil rights institutions and eroding protections for students. My amendment is very simple. It would ensure that the Secretary of Education does not fire the civil servants that investigate and combat anti-Semitism investigations in our schools. And it would ensure that the Secretary does not haphazardly reorganize the department's Office for Civil Rights, shuttering regional offices, including the one that serves students in my state of Maryland. In doing so, my amendment would prevent delays into investigations into anti-Semitism or other forms of discrimination in education. It would prevent this administration from making campuses less safe for not only Jewish students, but all students, by preventing ill-conceived cuts to the Office for Civil Rights. At the time this administration took over, there were 270 open OCR cases impacting 1.3 million students in my state, and without enough Office of Civil Rights staff to do the job, investigators' caseloads would grow to an untenable level. Students that face anti-Semitism may not have any recourse. Any effort to combat anti-Semitism in our schools must protect the very mechanism by which Jewish students can seek justice and redress for their discrimination. I urge my colleagues to vote yes on my amendment.
This addresses reduction in force or reorganization of the U.S. Department of Ed's Office of Civil Rights. This bill, aside from preserving freedom of speech, is also about protecting Jewish students on campuses. I call for the vote.
Senator Paul?
I shall be voting no.
Senator Paul?
No.
Senator Collins?
No by proxy.
Senator Murkowski?
No by proxy.
Senator Mullen?
No by proxy.
Senator Marshall? Senator Scott? Senator Hawley?
No by proxy.
Senator Tuberville?
No by proxy.
Senator Banks?
No by proxy.
Senator Houston?
No by proxy.
Senator Moody?
No by proxy.
Senator Sanders?
Aye.
Senator Murray?
Aye by proxy.
Senator Baldwin?
Aye by proxy.
Senator Murphy? Senator Kane? Senator Hassan? Senator Hickenlooper? Senator Markey? Senator Kim. Senator Blunt Rochester.
Aye by proxy.
Senator Alsobrooks. Chairman Cassidy.
No.
I have 11 ayes, 12 nays.
Mr.
Motion
Chairman,
not agreed to.
One more amendment, Senator Sanders.
call up Sanders Amendment number 5. This amendment provides for the consideration of a definition of anti-Semitism set forth by the International Holocaust Remembrance Alliance for the enforcement of federal anti-discrimination laws concerning education programs or activities and for other purposes. Once again, I think the point that we want to make is that in our country, people have a right to express their point of view, whether it is against the policies of the Israeli government or any other government or on any other issue.
I'd like to speak for the amendment.
Senator Paul. Senator Paul?
Yes, I'd like to begin by asking unanimous consent that we enter into the records the names of 400 Jewish American comedians who have referred to Jews in stereotypical language, which perhaps may be condemned by this bill, and I'd like to at least have their names introduced in the record as with my assertion.
Without objection.
When we think about, even saying Jews are funny is a stereotypical allegation, and I know some Jewish people who aren't, so it really obviously cannot be true of all Jews. But I wanted to read one, though, that I thought was particular. I was looking through these this morning, and there's just so many. I just didn't know how many Jewish comedians we had. This one's from Joan Rivers. She says, "I'm Jewish. I don't work out. If God had wanted us to bend over, he would have put diamonds on the floor." And that's obviously very negative, that Jewish people think only of money and stuff. But she's Jewish, and it's funny, but, or it's not funny, but it's just her right to, make a joke. But most jokes are about stereotypes. If you look at most of the Seinfeld episodes, there's the one on Native Americans and the totem pole and scalping of tickets and all these things that you're not supposed to say anymore. And, we become a humorless society if we want to restrict people's speech. And some of it is bad speech. And, I'm not going to a rally where people say Hamas is great. I think Hamas is awful and evil and committed murder and it's a massacre. But at the same time, I don't want to prohibit speech and protests on college campuses. And I just think it's a huge mistake, and realize that we are enforcing the Department of Education that has armed police to now enforce this new speech code.
Mr. Chairman? Mr. Chairman?
Senator Scott.
Thank you. Once again, I'll just reiterate the fact that one can say whatever they want to. That's protected by the Constitution. That's not even in question. The question is the conduct that follows. If the conduct itself is unlawful, the question is why. The examples in this legislation only provides direction on why. The conduct, not the speech, is what's in question.
I would, Mr. Chairman,
For time
briefly respond to Senator Scott. There are people in jail right now, who have not had any due process. You know why? They wrote an op-ed in their student newspaper.
The activity.
But according to this law, according to this bill, however, that would not be the case with this bill.
I'd like to also
You're
respond
talking about something that's already there.
No, we got to move. The activities in
I'd like
question
to
are already
respond.
protected by the rule of
I'd
construction.
like to have a vote on overruling the chair on whether I can have a minute to respond to the debate. And so let's have a vote on whether or not the chair gets to just dictate that we have no freaking debate over the First Amendment. I was looking for a minute, 2 minutes to respond to this, and not in a mean way. I like Senator Scott and respect him. I disagree with him on this, and I want to make a point.
We can have the vote and you can speak while we talk. But by the way, just to let you know, we are calling the floor to see if we can have a reconsideration of the 2-hour limit upon this committee hearing. I would ask none of my colleagues on the Democratic side to go to the floor to object. I would ask you to contact your floor leaders and ask them to not object. If you're truly interested in having a fulsome debate and not just using this as a way to kill the bill, then I would ask you to call your floor leader and ask not to put the 2-hour debate on us. I am operating under a constraint created by the minority. And I'm sorry about that, but we've got to get through the
Can I
legislation.
simply have 1 or 2 minutes and we don't have to vote to
1 minute.
chair 'em?
1 minute.
I'm not going to play that game. I
Well,
mean,
I'm sorry, then we gotta
60
go.
Seconds, then I make a motion that we overrule the chair on not allowing any kind of response to debate. I mean, that's just ridiculous.
Take your
Mr. Chair?
Take your 2 minutes.
Yeah, if the House can declare 1 day is the whole year, he can take 2 minutes, and
take
we'll
2
call it
minutes.
1 minute.
All right, very quickly, and I consider Senator Scott to be a friend. I would never insult him or say anything bad about him. But the notion that all this is about activities and not speech is belied by the 11 examples, because the words they use are calling for. Those are words. Making mendacious allegation. Those are words. Accusing Jews. Those are words. Denying the fact of the Holocaust. Those are words. Accusing the Jews as people. Words. Every one of the 11 examples of anti-Semitism is words, not actions. And it's interesting, when the chairman started this whole debate, he said, well, students shouldn't be allowed to take over campus. Well, absolutely not. That has nothing to do with speech. I wouldn't let students put up tents. I wouldn't let them do all that stuff. I wouldn't let them block students. I'd put them in jail for doing some of that stuff. But that's not speech.
Correct.
But if somebody gets up and says the river to the sea or whatever, you're going to put them in jail and stop them. That's speech. You can't regulate speech. Every one of the 11 examples is about speech. It is not about actions.
Mr. Ball, will you yield? You're within your 2 minutes, by the way. Well, simply stated, the examples point to the why the conduct that follows the speech is anti-Semitic. The examples, you can say every one of the 11 examples and not have any challenges as long as your next act isn't a conduct or harassment.
But it doesn't say that.
But the bill itself does. The examples are there simply to give the why.
That's why we should get rid of
conduct.
the examples to get rid. I'd be for your bill if we got rid of the examples, because the examples make it very confusing. The examples are all speech, not activities.
But the examples are not there to suggest that your speech is the issue, it's the conduct.
We don't know that because they're listed as examples of anti-Semitism that apply to the definition. We could simplify all of this and all be on the same page if we got rid of those definitions. Those definitions make it very, very confusing.
We shall vote on the amendment. The chair shall vote no. The clerk shall call the roll.
Senator Paul? Aye. Senator Collins? Senator Collins?
She is a no by proxy. I mean, yes by proxy.
Senator Rakowski? Senator Mullen?
No by proxy?
Senator Marshall? Senator Scott? Senator Hawley? Senator Tuberville?
No by proxy?
Senator Banks?
No by proxy?
Senator Heasted?
No by proxy?
Senator Moody?
No by proxy?
Senator Sanders?
Aye.
Senator Murray?
Aye by proxy.
Senator Baldwin?
Aye by proxy.
Senator Murphy? Senator Kane? Senator Hassan? Senator Hickenlooper? Senator Markey? Senator Kim? Senator Blunt Rochester? Senator Alsobrooks? Senator Murkowski? Chairman Cassidy?
No.
I have 13 ayes, 10 nays. The amendment's agreed to.
Sounds good. I'd like to propose a unanimous consent request that we ask the floor to waive the 2-hour limitation upon debate. That seems to be the issue here. That's what's put us constrained in terms of our debate. Is there any objection to that unanimous consent? So I'm asking unanimous consent to the committee requesting the floor to reconsider the 2-hour limitation upon our debate.
I asked for a 2-minute break. I want to talk to my colleagues.
Okay, 2 minutes. We're in a 2-minute recess, dependent upon the call of the chair. Again, what is before us is a request for unanimous consent for us to contact the floor and to ask them to waive the 2-hour limitation so that we can have this fulsome debate that everyone keeps requesting.
I object.
Okay, I think that tells volumes.
Well, good. They tell volumes, we're going to have a vote soon.
We're now ready to move on to the next bill.
Are you going to vote on this bill?
No, we're going to roll that to the end.
Hold it.
Rolling final passage to the end.
Ask for a vote on the waiving the 2-hour rule.
We'd like a vote on waiving the 2-hour rule.
I
Vote-
objected, so it's,
A vote yes is to waive the 2-hour rule. Clerk shall call the roll.
Senator Paul,
ask for clarification.
Hold on. Our parliamentarians are conferring. Go ahead. Okay, never mind. I'm told we can't vote on that. But it will be noted that the minority party does not want to extend beyond 2 hours of debate. Okay. At this time, per the discretion of the chair, we shall end the debate on the amendments. I will note that the number of amendments we've debated today are unrelated to protecting Jewish students or improving educational opportunities. This is kind of more of what we've seen, which is to oppose President Trump and his agenda at all cost. This is unfortunate, but Republicans will continue to work to improve the lives of American students and the American people.
Mr. Chairman, if I can very briefly respond.
Yes, sir.
What we have seen is a debate on whether or not this country moves toward an authoritarian form of society, whether we protect the Constitution and the First Amendment. I think that is of some importance.
We will now consider S-163, the Protecting Students on Campus Act of 2025. We have a manager's amendment. I move to adopt the manager's amendment in the nature of a substitute and have it to be considered original text for the purposes of further amendments. All those in favor, please say aye. Aye. All those opposed, say nay. The ayes have it. The motion is agreed to. Are there any members who wish to speak or offer an amendment to S-163?
Mr. Chair?
Senator Hassan.
Thank you, Mr. Chair. I want to start by saying that I am not going to offer Hassan Amendment number 1, which would expand the focus of the Civil Rights Awareness Campaign and other requirements created in this underlying bill to include additional forms of discrimination, such as discrimination against students with disabilities. Because the chair has indicated that he wants to work with us on this amendment, on the substance of this amendment, in a different way, with a different bill, I will not offer that, and I appreciate the chair's constructive approach here. I do have 2 additional amendments, but I don't want to speak out of turn. So I just wanted to acknowledge your willingness to work on the content of Hassan Amendment number 1.
It's always great to work with you, Senator Hassan.
Thank you.
Yeah, Louisiana-New Hampshire connection.
Thank you. I do have 2 other amendments. I just don't know if other people want to go first.
Why don't you go?
Okay. I want to bring up and offer Hassan Amendment number 2. I'd like to offer this so that we can ensure that the Department of Education's Office for Civil Rights can close a complaint if requested to do so by the student who filed the original complaint. Under current policy, the Office for Civil Rights can dismiss a complaint if it is withdrawn by the student or individual who filed it. However, the bill we are considering would take away the ability for the Office for Civil Rights to close a case if it is closed by a school at the request of the student who filed the complaint. We have to ensure that students retain some level of autonomy and have a say in the pursuit of the civil rights complaints that they file, so I urge my colleagues to vote yes on Hassan Amendment number 2.
Senator Cassidy will also be voting aye. I ask the clerk to call the roll.
Senator Paul,
Senator Paul is a yes by proxy.
Senator Collins,
Is a yes by proxy?
Senator Murkowski,
Yes by proxy, I'm sorry.
Senator Mullen,
No by proxy?
Senator Marshall, Senator Scott,
No by proxy?
Senator Hawley, Senator Tuberville,
No by proxy?
Senator Banks,
No by proxy.
Senator Houston,
No by proxy.
Senator Moody,
No by proxy.
Senator Sanders,
Aye.
Senator Murray,
Aye by proxy.
Senator Baldwin,
Aye by proxy.
Senator Murphy, Senator Kane,
Aye by proxy.
Senator Hassan, Senator Hickenlooper, Senator Markey, Senator Kim, Senator Blunt Rochester, Senator Alsobrooks, Chairman Cassidy.
Senator Cassidy is an aye.
You have 17-6. I have 17 ayes, 6 nays. The amendment is agreed to.
Amendment's agreed to. Is there anyone else to offer an amendment?
Chairman,
Senator Sanders.
I call up Sanders Amendment Number 4. This amendment is simple and straightforward. It simply requires the Inspector General to issue a report within 6 months auditing DOGE employees and their role in the Department of Education's decision-making and layoffs. DOGE and Elon Musk have already laid off half of the Department of Education staff, which is jeopardizing the education funding, the civil rights, and the financial aid of students throughout the country. Congress and the public still do not have information on which staff were fired, what their responsibilities were, or the department's plan to ensure programs still function. We have a responsibility to receive this information. I urge my colleagues to vote yes on this amendment.
We're closely following what DOGE is doing. This markup is about protecting students on college campuses and has nothing to do with DOGE. The clerk shall call the roll. I shall be voting no.
Senator Paul,
Senator Paul is a no by proxy.
Senator Collins,
No by proxy.
Senator Murkowski. Senator Mullen,
No by proxy.
Senator Marshall,
No by proxy.
Senator Scott,
No by proxy.
Senator Hawley, Senator Tuberville,
No by proxy.
Senator Banks,
No by proxy.
Senator Houston,
No by proxy.
Senator Moody,
No by proxy.
Senator Sanders,
Aye.
Senator Murray,
Aye by proxy.
Senator Baldwin,
Aye by proxy.
Senator Murphy, Senator Kane,
Aye by proxy.
Senator Hassan, Senator Hickenlooper,
Aye by proxy.
Senator Markey, Senator Kim, Senator Blunt Rochester, Senator Alsobrooks, Chairman Cassidy.
No. No by proxy. No.
I have 12 ayes, 11 nays. The amendment's agreed to.
For the benefit of my colleagues, we shall start voting on final passage of these two bills about 20 till. We've got to give a little extra time because people have to return. Obviously, as we all know, people are being pulled in different directions. Senator Hassan.
Thank you, Mr. Chair. I'd like to offer Hassan Amendment 3 to Senate 163, the Protecting Students of Campus Act. This amendment would nullify President Trump's executive order to close the U.S. Department of Education. It is absurd as we are talking about the important work that the Department of Education does in helping students pursue higher education, that the president is working to entirely eliminate the Department of Education. My amendment would prevent the president's reckless and misguided assault on the Department of Education's critical work to support students and schools across the country. So I ask for a vote, and I urge my colleagues to vote yes.
This amendment is a distraction, and I recognize this is important, but Congress cannot overturn executive orders. It is not within the scope of what we're considering. So I move to table Amendment number 3 of Senator Hassan on Senate 163. For clarification, a yes vote means the amendment will be placed on the table, no longer considered for passage. I shall be voting yes. The clerk shall call the roll.
Senator Paul,
He is a yes to table by proxy.
Senator Collins,
Yes by proxy?
Senator Murkowski.
Yes.
Aye. Okay. Senator Mullen,
Yes by proxy?
Senator Marshall,
Yes by proxy?
Senator Scott,
Yes by proxy?
Senator Hawley,
Yes by proxy?
Senator Tuberville,
Yes by proxy?
Senator Banks,
Yes by proxy?
Senator Houston,
Yes by proxy?
Senator Moody,
Yes by proxy.
Senator Sanders, Senator Murray,
No by proxy.
Senator Baldwin,
No by proxy.
Senator Murphy, Senator Kane,
No by proxy.
Senator Hassan,
No.
Senator Hickenlooper,
No by proxy.
Senator Markey, Senator Kim, Senator Blunt Rochester, Senator Alsobrooks, Chairman Cassidy.
I am a yes to table.
I have 12 ayes, 11 nays. The motion is tabled. Yeah, the amendment's tabled.
Just to let everybody know, on our side, we're contacting people to come back for the vote. I assume that you guys would like to contact your members as well, but you don't have to. And so we shall proceed to the next amendment. Yes, ma'am.
Mr. Chair, I have an amendment at the desk, and I ask that you call up Alsobrooks number 1 to S-163. Mr. Chair, I want to make this as simple as possible. No one should fear their safety at school because
I'm sorry, this is number 1?
Yes. No one should fear for their safety because of who they are, and students that face anti-Semitism or any form of discrimination should have recourse against that discrimination. Yet this administration just summarily fired half of the civil servants at the department's Office for Civil Rights and shuttered OCR regional offices. Offices including the Philadelphia Regional Office, the very office that reviews discrimination cases in my state of Maryland. These OCR offices served nearly 60,000 public schools and over 30 million K through 12 students. I want to really make this clear for the American people. When decimating the Department of Education and the Office for Civil Rights, Office of Civil Rights attorneys intervene when schools ignore complaints from students who are repeatedly called racial slurs or subject to hateful speech or imagery, like the swastikas on campus. It provides the technical assistance that schools need to train staff on anti-harassment practices, combat harmful behaviors, and build welcoming environments. And it holds K through 12 schools and colleges that fail to meet this standard accountable. So my amendment would assure that the Secretary of Education does not fire the civil servants that investigate and combat anti-Semitism investigations in our schools. I urge my colleagues to vote yes on my amendment.
This is an amendment which relates to reduction in force or reorganization of the Office of Civil Rights. It is not related to the bill which is before us. I shall oppose. The clerk.
Mr. Chair, can I just say a quick word here?
Yes, sir.
Yeah, I just wanted to thank my colleague here for raising this as well as in the previous bill, because I do think that as we're talking as a committee about what types of parameters we should be looking at and whatnot, we should be also thinking about how that is executed and implemented. And I think that that is what the senator was getting at, and I think that is very much in the purview of this committee. And when I see the types of cuts to the Office of Civil Rights, as well as the language about abolishing the Department of Education, it does worry me greatly about how we are actually able to tackle anti-Semitism and other types of discrimination on college campuses. So I just wanted to be able to lend my name in support of this effort to stand up for our efforts to implement and execute protections for students.
The clerk should call the roll. The chair shall be voting no.
Senator Paul,
No by proxy.
Senator Collins,
No by proxy.
Senator Murkowski, Senator Mullen,
No by proxy.
Senator Marshall,
No by proxy.
Senator Scott,
No by proxy.
Senator Hawley,
No by proxy.
Senator Tuberville, Senator Banks,
No by proxy.
Senator Houston,
No by proxy.
Senator Moody,
No by proxy.
Senator Sanders,
Aye.
Senator Murray,
Aye by proxy.
Senator Baldwin,
Aye by proxy.
Senator Murphy, Senator Kane,
Aye by proxy.
Senator Hassan, Senator Hickenlooper,
Aye by proxy.
Senator Markey, Senator Kim, Senator Blunt Rochester, Senator Alsobrooks, Chairman Cassidy.
The senator opposes.
I have 11 ayes, 12 nays. The amendment's not agreed to.
Another amendment.
Mr. Chairman,
Yes, ma'am.
I call up my amendment number 2.
Senator?
This amendment would create a new reporting mechanism to increase transparency within the Department of Education. Basically, it follows on the last amendment that as we look at implementing these bills, there must be capacity to implement them, particularly when we're seeing potential elimination of the Department of Education, as well as shrinkages in the full-time staff. And so specifically, it would require the Secretary of Education to report to Congress every 30 days on the number of full-time staff by role in office. And it would also require the submission of an updated organization chart with that monthly report. Since this administration has been focused on transparency and talk about efficiency, I hope that my colleagues will see this amendment and its importance, and that it's simple and straightforward. We should ensure that we in Congress can provide the oversight that we were meant to have over the executive branch. And I urge my colleagues to support this amendment, and I ask for the yeas and nays. Yield back.
Well, I recognize this issue is an important one to the members, to Senator Blunt Rochester. The issue is not within the scope of the legislation that we are considering. So I move to table amendment number 2 for Blunt Rochester, of Senator Blunt Rochester for S163. Is there a sufficient second? For clarification, a yes vote means the amendment will be placed on the table and no longer considered for passage. I shall be voting yes. The clerk shall call the roll.
Senator Paul.
Senator Paul is a yes by proxy.
Senator Collins.
Yes by proxy?
Senator Murkowski. Mullen. Senator Mullen.
Yes by proxy.
Senator Marshall.
Yes by proxy?
Senator Scott.
Yes by proxy?
Senator Hawley.
Yes by proxy?
Senator Tuberville. Senator Banks.
Yes by proxy?
Senator Houston.
Yes by proxy?
Senator Moody.
Yes by proxy.
Senator Sanders.
Nope.
Senator Murray.
No by proxy.
Senator Baldwin.
No by proxy.
Senator Murphy. Senator Kane.
No by proxy.
Senator Hassan. Senator Hickenlooper.
No by proxy.
Senator Markey.
No by proxy.
Senator Kim. Senator Blunt Rochester. Senator Alsobrooks. Chairman Cassidy.
I am a yes to table.
I have 12 ayes, 11 nays. Motion is tabled.
Do we have another amendment?
Mr. Chairman,
Senator Blunt Rochester.
thank you so much for the recognition. I call up amendment number 3.
Senator shall proceed.
This amendment is something that I think all of us can agree on. It's simple. The Protecting Students on Campus Act would create a public awareness campaign for submitting civil rights complaints at institutions of higher education. And my amendment would assure that the campaign is accessible and ADA compliant. If we want students to be able to submit complaints, we need to make sure that all students can do so equally. That means creating campaign materials with Braille or audio accompaniments for visually impaired students. It means ramps to the Office of Civil Rights on college campuses for students who use mobility aids. It means ASL interpreters in those offices for students who are deaf or hard of hearing. It means universal design with accessibility in mind. I'm sure my colleagues want to protect access to civil rights for all students, and I urge all of you to support this amendment. I ask for the yeas and nays, and I yield back.
This is a common sense amendment ensuring all students will be able to understand and access public awareness campaign for their Title VI rights. I thank Senator Blunt Rochester for this thoughtful and constructive amendment. I shall be voting yes. I ask for the clerk to call the roll.
Senator Paul.
Senator Paul is a yes by proxy.
Senator Collins.
Yes by proxy.
Senator Murkowski. Senator Mullen. Senator Marshall.
Yes by proxy.
Senator Scott.
Yes by proxy.
Senator Hawley.
Yes by proxy.
Senator Tuberville.
Yes by proxy.
Senator Banks.
Yes by proxy.
Senator Houston.
Yes by proxy.
Senator Moody.
Yes by proxy.
Senator Sanders.
Aye.
Senator Murray.
Aye by proxy.
Senator Baldwin.
Aye by proxy.
Senator Murphy. Senator Kane.
Aye by proxy.
Senator Hassan. Senator Hickenlooper.
Aye by proxy.
Senator Markey.
Aye by, aye by proxy.
Senator Kim. Senator Blunt Rochester. Senator Alsobrooks. Chairman Cassidy.
Chairman Cassidy is an aye.
23 ayes, 0 nays. The amendment's agreed to.
I think we have time for one more amendment. Is there another amendment?
I think that Patty is going to try to be here. What's the story? Patty is on the way, and she would like to offer an amendment.
We're about run out of time. Murray, I think we have time for one more amendment. Senator Murray?
Thank you so much. I really appreciate it. And I want to call up Murray Amendment number 1 and speak in favor of my amendment. It is very simple. It would require the Secretary of Education to restore staffing levels for the investigative staff at the Office for Civil Rights and restore the regional office structure that existed before Trump took a hatchet to that office. Trump has fired nearly half the agency and shuttered more than half of the OCR offices. These actions have thrown 6,000 cases into question and left students in 28 states without the necessary resources to fight back. We cannot protect students on campus if we do not have the necessary staff at OCR. If we are serious about fighting anti-Semitism, if we are serious about protecting students from illegal discrimination, we need to get serious about staffing at the OCR, and I request the yeas and nays on my amendment.
We're following the staffing and organizational changes at the Department of Ed, but this legislation is not the place to consider that. The chair shall be voting no. The clerk shall call the roll.
Senator Paul?
No by proxy?
Senator Collins?
No by proxy?
Oh, no.
Oh, I'm sorry.
No present. Okay. Senator Murkowski? Senator Mullen? Senator Marshall?
No by proxy?
Senator Scott?
No by proxy?
Senator Hawley?
No by proxy?
Senator Tuberville?
No by proxy?
Senator Banks?
No by proxy?
Senator Houston?
No by proxy?
Senator Moody? Senator Sanders?
Aye.
Senator Murray? Senator Baldwin?
Aye by proxy.
Senator Murphy? Senator Kane?
Aye by proxy.
Senator Hassan? Senator Hickenlooper?
Aye by proxy.
Senator Markey?
Aye by proxy.
Senator Kim? Senator Blunt Rochester? Senator Alsobrooks? Chairman Cassidy? Chairman Cassidy?
Senator Cassidy is a no.
I have 11 ayes, 12 nays. The amendment's not agreed to.
I'm getting my folks back over here. I think we have time for one more amendment, perhaps. Does anybody else have another amendment? Okay, we'll be in recess, subject to the call of the chair, but it shall be shewn. We will defer the vote for another day. The committee stands adjourned.